A lot of people think when they're arrested for DUI that the game's over, it just can't be defended, and they think everything is done. And I've had some very depressing interactions with other people that they didn't know that they could fight their DUI charge, that they think it's not something that's even up for discussion. And I've even had some conversations with other lawyers thinking, can you even fight a DUI? Can you even defend a DUI? Well, the answer is, of course you can. I want to do a quick little series of videos on the subject of trial defense of DUI charges in California. Now, you might have picked up on some of the issues that I'm going to talk about here if you've watched our other videos on DUI defense in general. I'm going to try to put them all together right here to talk about specifically whether or not you have a good defense at trial for your DUI charge. A lot of people think when they're arrested for DUI that the game's over, it just can't be defended. They remember the night very well, and the BAC is measured above 0.08, and they think everything is done. And to the point where they think they're not even allowed to go to trial in some DUI cases. I've had some other people come to court alone, and they just know they're accused of DUI. They're being spoken to maybe by other people in court and try to compare their situation. They might honestly not even know that they're allowed to fight a DUI charge. Because whether we like it or not, in this country, the Sixth Amendment of the U.S. Constitution guarantees you the right to have a jury trial. If you are accused of a misdemeanor offense, you have the right under the Constitution to a jury trial. If they want to actually find you guilty and potentially punish you in criminal court for a misdemeanor offense, they have to be able to prove every element of the offense beyond a reasonable doubt to a jury of their peers. And in California, like many other states, the size of a jury for a misdemeanor case is 12 people. You have the right to take your case to a jury trial where you get to confront and cross-examine witnesses, present evidence, subpoena witnesses, testify or not testify on your behalf, and of course have the right to effective assistance of counsel. You have all of these same rights no matter how good or bad your DUI case is. And it's important to know how valuable they are in a given case. At the end of the day, when somebody is accused of a criminal offense, the courts and prosecutors know that at the end of the day, at some point, if they're going to have a conviction, the prosecution has to be able to prove them guilty beyond a reasonable doubt. And that takes work. The prosecution has to present the evidence for you and your lawyer to confront. The defendant has to be given the opportunity to have their own attorney, if they can't afford one, to have an attorney appointed for them. And to take the time it takes for everyone has a fair chance of selecting the people on that jury. And preparing to question the witnesses, not just the police officers on scene, but also maybe any civilians who might have been witnesses to the event. Maybe any of the scientists, the toxicologists who might be involved, either in directly testing or analyzing the tests associated with the defendant's arrest. It's a lot of work, and that's why it requires a lot of attention from any competent counsel on either side of the aisle. In cases where people feel like they've gotten good offers for DUI cases, it's usually at least in part, based on the discussion of trial defense. Hey, if this case goes to trial, this might happen. You might have a hard time proving this. So therefore, why don't you just make this alternative, less conventional offer instead? You'll be surprised how much better the results can be simply by setting a case for trial and preparing it that way. But I also want to talk about the actual defense of a DUI charge at trial in California, the actual defense of doing that. Because even if you think everything looks cut and dry, and you're going to court, maybe by yourself, you're all stressed out, you're worried about what other people in court or the prosecutor might say to you, you have all these rights, and it's important to know what happens when you choose to flex them. Because you never know what's going to happen when you take the right case to trial. And no matter how bad you might remember the incident, a not guilty is still not guilty. You have every right to tell the prosecution, prove it. And if you can't, I shouldn't have to suffer a penalty. And any lawyers who is fit for you should be willing to understand that, be willing to develop that with you. If you or anybody you know is concerned about fighting a DUI charge, please give us a call. Thanks, and stay safe out there.